morning to everyone, and welcome to our CPDP event on data protection revolutions in the Brics countries. So this event is organized by the Cyber Brics project hosted by FGV Law School, but is a partnership with several other key academic institutions in the Brics countries, so in Brazil, Russia, India, China, and South Africa. My name is Luca Belli. I'm professor at FGV Law School, and I head the Cyber Brics project. And together with me today, there will be some Cyber Brics friends that are key leaders and specialists of data protection in their respective countries. In Brics order, let me introduce you to Danilo Doneda, professor of the Brazilian Institute for Public Law and also one of our Cyber Brics associated scholars, and last but not least, also a member of the newly created Privacy and Data Protection Council, which is an advisory body to the newly created Brazilian Data Protection Authority. Following the Brics order, then we have Professor Andrzej Szczerbovic, who is our visiting professor specializing in Russian digital policies at the Cyber Brics project. We have then Smriti Parshira, that is a researcher at the National Institute of Public Finance and Policy in New Delhi, and also a Cyber Brics research fellow for the years 2020 and 2021. We have also Wei Wang from the University of Hong Kong, and also a Cyber Brics fellow for 2020 and 21. And last but of course not least, Professor Silva Snail, that is both a member of the board of the Cyber Brics project and also a member of the board of the Information Regulator of South Africa, the Data Protection Agency of South Africa. We have decided to convene this session today because there have been, as the panel title suggests, really not only major evolutions, but in some countries we may really characterize them as revolutions in data protection over the past year in the Brics countries. To provide you a little bit of example, in Brazil, the new data protection law, the LGPD, entered in force finally in September 2020, although only partially, and we will discuss this with Danilo, and a new data protection authority is in the process of being created. In Russia, meanwhile, there has been an extensive implementation of COVID-19 measures and also an artificial intelligence strategy. Needless to say, both make intensive use of personal data. In India, the new data protection bill should be tabled in the upcoming session of the Indian Parliament, and the Indian government is also studying a new data empowerment and protection architecture, which is a particular system to manage consent. China has just released a couple of months ago its draft personal information protection law. Only a couple of weeks ago, the new Civil Code of China entered in force, creating a new right to privacy and personal information protection. And China also plans a global initiative on data security, so major developments on the Chinese front. And last, but of course not least, South Africa is going to implement POPIA, the Protection of Personal Information Act, that is now under this 12-month grace period, but it's already being tested by recent events. Now, although we usually start and follow the Brics order, we decided today to, as we are speaking about revolutions, to revolutionize this order and to start in reverse order with South Africa and then the others until the B of Brazil. So without further ado, I would like to sincerely welcome all the panelists and give the floor to our friend, Professor Sizwe Znail. Sizwe, it's a great pleasure to have you here. Please let us understand what is the current situation in South Africa with regard to data protection. Thank you very much.
Thank you very much, Prof. Belly, and thank you very much for inviting the information regulator once again to this prestigious event dealing with data protection. And it gives me great pleasure to be here again, because exactly about a year ago, we were in Brussels at the same event, and I was busy telling the participants of the conference that our data protection law will come into force by the second half of the year. To not much surprise, the state president reacted to the request from the information regulator to put the remaining forces of POPIA into law. For those of you who don't know, POPIA came into force in 2013, but only certain sections of the POPIA. So it was the section dealing with definitions and the sections dealing with the creation of the Office of the Information Regulator. As of the 1st of July from last year, we have now entered what we call our grace period. And in this grace period, the remaining sections, in other words, now from section 1 right up to section 114, the entire act has now come into force subject to the grace period. Now, we always get the question, must we not comply during the period of the grace period? The answer to that is quite simple. The grace period is a period for responsible parties or controllers, as you would know them, responsible parties to get their house in order. In other words, it's not a period not to comply. It's a period to check whether people are complying with the law and to look at the loopholes that one may have in terms of their own compliance, so that when the 1st of July comes, that everybody is compliant. So that is what the grace period is about. We said we are data subjects to get their houses in order for them to comply. Beyond the grace period, there may be an additional 12 months if the regulator deems it fit for the grace period to be extended. But as you know, we are living now in the COVID-19 world. Any country that does not have data protection or does not have adequate data protection or data protection in force is really a country that is playing with its citizens' human rights. You will know we have apps that now track and trace data subjects, their activities, as well as their statuses of COVID-19. So, you know, not just the apps, but other aspects, you know, where there are numerous places now where your personal information is being collected, be it at the workplace, be it at a restaurant when you step in. You know, there are many instances where personal information is collected, and as a result thereof, you know, it is really, really, really essential that the POPIA is now a tool that can enforce data protection legislation.
Yes.
For a very, very long time, it was said that the POPIA is toothless, because the remaining sections were not enforced. They are now enforced. We are
I am sharing my
proactively
screen.
everyone in South Africa, all responsible parties, to really now focus on compliance and to ensuring that data subjects' personal information is being protected. So that's basically the development that we have coming from South Africa. We have had several data breaches as well in South Africa over the last couple of 6 months. And the Office of the Regulator has really shown its teeth by going and investigating these data breaches. As much as we will not be able to give any fines and any punishments, the regulator has really gone out of its way to investigate these things and to see where the errors were and assisting responsible parties with notifying data subjects of these breaches and taking the relevant steps in order to ensure that, you know, when the grace period comes, they may not suffer any data breaches. Obviously, data breaches are not something that controllers have in their control. Data breaches can be as a result of rogue employees, can be as a result of criminal actions. But I think the POPIA, and in particular the principle dealing with cybersecurity and the protection of personal information, really now creates a positive duty upon controllers or responsible parties, as we call them, to really ensure that they don't only process personal information in line with POPIA, but they really toughen up their security measures in order not to be susceptible or to be victims of data breaches, which will then make them liable to having to notify data subjects as well as the information regulator. So I think that is the overall development that we've had in South Africa. Also looking on the African continent, since we're the only African country from Brics, the whole of Africa really following suit as well. We do now also have the Roundtable of African Data Protection Authorities, which is really fast tracking and really pushing awareness and capacity initiatives in the entire of Africa, be it West Africa, East Africa, or the Southern Africa, to ensure that really data protection is not just a like have or a want have, but it is actually a reality. Thank you, Propeli.
Thank you very much, Professor Sizwe Nair, for this excellent introduction. And actually, we start to distill some first good practices that actually could be also expanded to all Brics. What you were mentioning, the fact that the grace period is actually a period not to leave the Data Protection Act in a drawer, but actually to start complying and organize compliance on the one hand. On the other hand, for the DPAs, it's a moment to start on the assessing the situation, checking whether how compliance is implemented by the various controllers or operators, and on the other hand, also it's a moment of pedagogy for the DPAs that have to assist not only to sanction and monitor, but also to assist all potential public or private entities interested and obliged to comply with the law. Thank you very much for this. Now switching to our next panelist, Wei Wang. Wei, we have heard really incredible changes being not only planned, but already implemented by China over the past couple of weeks and months. Please let us understand what is in the pipelines for China with regard to data protection.
Okay, thank you, Professor Belli. And it's my, let me start titling the first flow. Okay, hello everyone. This is Wei Wan. I'm from University of Hong Kong. Today, I'm very happy to present a topic relating to the Chinese Draft Personal Information Protection Act and its potential impact in the near future. Basically, I will brief you on the brief history of the Chinese conception of personal information and what the Personal Information Protection Act requires in its legal texts. And I would ask the puzzle relating to data security and the personal information in the Chinese context. And I will I will let you know a new trend of using antitrust to address unfair automation by algorithm in China. So basically, the Chinese constitution stipulates the right to privacy, but unfortunately, it's largely unenforceable. But in 2017, the Chinese cybersecurity law deal with the pre-consent principles and system security relating to information interacting with critical information infrastructure. And last year, the first Chinese civil code was adopted, and it came into effect on the first day of this year. It's Chapter 6 of Part 4 emphasizes the privacy and personal information in particular, but there is a vague boundary between privacy and personal information. But finally, the legal scholarship has agreed that personal information in China is a kind of a bundle of rights. There are also some sectoral regulations and national standards relating to, regulating telecommunications and the internet industries that can help us to understand practical compliance requirements. So, what does the PIPA require? It is now still under review of China's National People's Congress. The draft consists of the 8 chapters and 70 articles. Very interestingly, the Chinese public authority adopted a multi-stakeholder approach to collecting public comments. Those comments are super interesting, but due to time limit, I will just jump over them. So, firstly, the PIPA clarified sensitive personal data. It says sensitive personal data can only be processed if there is a specific purpose and sufficient necessity, and the individual's separate or written consent should be obtained. And it is emphasized that personal data should be processed in a legal and limited way with a clear and reasonable purpose, limited to the minimum scope to achieve the purpose of processing. And it tried to ensure the accuracy of data and take security measures and such. I think the biggest breakthrough of the PIPA is that it introduced the informed consent principle. And there is also a special section on the rules governing the processing of personal data by state organizations, which requires state organizations to process personal data in accordance with the limits of authority and the principles prescribed by law and other regulations. And secondly, PIPA was also involved with extraterritorial jurisdiction. The draft stipulates that this act shall also apply to personal data processing activities that take place outside China for the purpose, firstly, for the purpose of providing products or services to domestic natural persons, or secondly, for analyzing and evaluating the behavior of domestic natural persons. It also requires overseas personal data processors, or we can say data controllers, to set up special agencies or representatives in China that will be responsible for personal data protection related matters. And the informed consent principle was also extended to the scenario of personal data, cross-border personal data flow. The draft makes it clear that the operator of critical data infrastructure and processors who deal with personal data up to the amount specified by the National Administration of Cyberspace, and who really needed to provide personal data broad shall go through the security assessment organized by the National Administration for Cyberspace. And it also introduced some pre-approval process in terms of the international judicial assistance or administrative law enforcement assistance. So, as you may notice, that the POPIA shares a similarity with GDPR, but there is it has an ambiguity of data subjects, or we can see parties. Although there is a redress mechanism, roughly we can say the National Administration of Cyberspace will be in charge of managing the mechanism. It's unclear how a specific regulator may work in this case. And it also introduced some assessment, for example, security assessment and risk assessment, particularly in the scenario of cross-border personal data flow. So it reminded me of the puzzle relating to data security and personal information in the Chinese context. Just before PIPA, the Draft Data Security Act was released as well. It addressed the issue of governmental data and the security values. Some legal scholars in China argued that these security values should include personal, public, and national security. So, but how do we understand the security concepts across jurisdictions, particularly in cross-border data flow? Also, last year the Global Data Security Initiative was proposed to try to strike a balance between supply chain security and the digital economy, but it also related to some very hot topic, for example, cyber sovereignty or data sovereignty, and I would also like to draw your attention to some assessments and the data risk rating proposed by PIPA. For example, how about the mass personal information collection or biometric personal information collection, and how do we define the risks here in terms of the requirements? And I would like to introduce a quotation from the Social Dilemma documentary by Netflix. If you are not paying for the products, then you are the product. So China is also introducing the antitrust investigation to online platforms in terms of the algorithmic occlusion based on personal information profiling. We had an anthropology of data as money, surveillance infrastructure, and for complaints, there are some emerging business models towards profiting from user profiling, privacy, and personal data, for example, precise advertising. And the PIPC introduces some articles relating to anonymization and de-identification, but it has been so far unclear how these articles will work in the near future. And very recently, the Chinese government introduces the anti-monopoly guidelines in the field of platform economy, particularly in the field of big data analytics and social phenomena. You can understand social phenomena as price discrimination by algorithm. And the Article 17 of the guidelines just regulated some circumstances, for example, based on big data and algorithms, differential transaction prices or other transaction conditions based on the transaction counterparty's ability to pay, consumption preferences, or usage habits. So I'm personally looking forward to the new cases arising from these guidelines as well. Okay, I think this is what I would like to update to you today. Thank you. I will hand it back to Professor Billy.
Thank you very much, Wei, and thank you very much all panelists so far for respecting the time slots of maximum 10 minutes so that we will have enough time for discussion. Very good to see the evolution that China undertook over the past years. Started with strong cybersecurity law on which data protection was, on top of which data protection was built, then moving to more elaborated data protection concepts, informed consent, even extraterritorial jurisdiction. It takes a lot of inspiration from GDPR, as many other Brics framework do. And actually, we have a paper on this in our publications on cyberbrics.info that I invite everyone to check. And there will be more that Professor Daniel Domed and I also are trying to publish as soon as possible on this topic. Another very important point from China is the emerging role of antitrust. You were striking a very important chord way when you mentioned the anti-monopoly guidelines and the Shashu phenomenon. China has been hitting the headlines for the inquiries on big Chinese platforms over the past weeks, and it's joining the world movement towards a stronger implementation of antitrust and even consideration of privacy and data protection as criteria for antitrust implementation. Now, without further ado, let me ask Smriti Parshira, that is kindly with us today, to provide a little bit of insight on the latest evolution on the Indian front. Thank you very much, Smriti, for being here with us today. The floor is yours.
Thank you. Thanks a lot, Luca. It's a pleasure to be here, and I'm looking forward to the rest of the discussion. I'm going to talk in the next few minutes about some of the discussions that have been going on in India in the last 1 year, but also tracing it back to a little before that. So here are some of the key developments you see on the screen, that from 2017 till until now, we've had some movements that has happened on this topic, starting from when the Supreme Court of India in a 9-judge bench declared that privacy is a fundamental right. And one of the offshoots of this case was that the government decided to constitute a committee which would look into this question of data protection, both by the private sector and by the state. And they came up with a draft bill, which eventually, went to the government following a consultation process, etc., and is now something which has been tabled in the parliament. And as you said in the introduction, there has been a joint parliamentary committee that's looking into it, and they are likely to table the revised version of the bill following further consultations in the next couple of days, because the session starts in about 2 days, and then they have time to April. So in this window, it's expected that we're going to have another version of the bill. But what I'll talk through right now is a couple of key points from the existing version, which is in the public domain. But before I do that, here is just an overview. So it's not like we have no data protection right now, but as I'll give you a gist, what we have in the law currently is highly inadequate given the kind of data processing we're seeing today. So we have a provision in our information technology law which talks about compensation in case an entity fails to protect data, but this is limiting in many ways. One, because of the kind of coverage, it only covers body corporates. It doesn't cover the state and any of the functions of the state at all. It only covers sensitive personal data. It only covers a sliver of the kinds of rights and protections we would expect from a data protection law, because it only talks about reasonable security practices that need to be maintained in respect of this sensitive data. And there again, there have been rules framed by the government which go beyond talk about things like consent and purpose limitation, etc. But the legislation itself has a very limited scope. And this is, of course, worrying, because not only is massive data processing happening already in the private sector, there is a lot of action which is happening at the states, and where we've got a huge digital identity program running. Now, during the pandemic, we've had a large contract tracing program running through the mechanism of an app as the interface. There is a new process where vaccinations are going to be linked to an app. There is a health data ID program. So in so many respects, there is a lot of potentially very intrusive practices dealing with sensitive data, and therefore the bill that I'll just discuss in a moment becomes all the more important. So here are some key concepts, and of course, this bill, in many ways, like some of the other laws we've been discussing, mirrors what are now regarded as the best practices of data protection. So I'm not going to go into the overall framework of the bill, but here are some concepts which are interesting or in some ways different from what you're seeing elsewhere. So the first is, the concept of the definitions itself, where they use the concept of a data fiduciary instead of the term like you would see in GDPR, a data controller. And the logic given by the committee that framed the bill was that they want this relationship of trust and the need to act in the best interests of the entity to come out in the data protection bill. And therefore, instead of calling someone the controller and a subject, they want to call the individual the principal, and they want to call this entity the fiduciary. Whether this will really affect something in actual practice or will it just be a term, of course, we'll only get to know once this bill is in force. The other thing, as we see on the slide up here, is the question around consent management. And like all data protection laws, it does give a consent of, important place in terms of a ground for processing. And it talks about the role of consent managers to operationalize this transmission of consent from the individual to people who may want to take her data. And in parallel, we are seeing the development of this technical architecture, which is something outside the bill, but it's something which is already being operationalized in several sectors and discussed in a few more, which is called the data protection and empowerment architecture. And the idea here is that there will be a third party called a consent manager who forms this interface between the user and entities which have her data and which want to access her data. So as we can see from the example here, suppose there is a wealth management firm which wants a user's data in order to offer services to her, and her data is held currently by banks and insurance companies. Then instead of the firms directly speaking to each other, this consent manager will act as an intermediary using something which is called a consent artifact, which is basically a technological token which is going to contain details such as who wants the data, for what purpose, what is being disclosed. All of this will be recorded in that artifact. And using that, this information is supposed to flow from one entity to the other, while the consent manager itself remains blind to the data that's being transmitted. That will be in an encrypted form. So here's one way where consent, with all of its problems, can be slightly improved, is the hope out of this architecture. Some of the other interesting concepts or problematic in some way concepts is one of the contentious issues around this bill is the very wide scope of exemptions that it gives to state authorities, to law enforcement agencies. So unlike a lot of other countries, in India, we don't have a separate legislation or any kind of a legal framework which is robust and which regulates the use of personal data by state agencies and intelligence agencies. And what this bill does is, in addition to one provision which says that you'll have a carve out for law enforcement purposes, you also have a very broad provision which tries to say that the government can essentially exempt any state agency based on certain functions like security, etc., from the complete purview of this act. So it's not just a functional exemption, it's an agency-based exemption, and that is something a lot of us are pushing back against, and that is something which is problematic in the bill, but we need to see how that changes in the next draft. Some of the other interesting developments that are taking place is that in line, along with the personal data conversation, the conversation has started on what should be the policy framework around non-personal data. So this is data which is basically just defined as non-personally identifiable information. And this bill sort of tries to do a little bit of land grab by saying that not only will we regulate personal data, there will also be scope for the government to call for non-personal data, which is either personal data which is anonymized or data which was never personal, say air pollution or data like that, which was never identified and linked to an individual. And this kind of data can be called for by the state for certain purposes. And in parallel with this, there is a separate committee process which has come up. So really, again, we need to see how this bill is going to make these two things talk to each other. And finally, I just want to discuss, the role of the Data Protection Authority in all of this, because we're talking about, for the first time, a law which is really comprehensive, which is capturing both the state, which is capturing private entities. And therefore, it becomes really important to talk about regulatory governance and state capacity issues in what this authority will look like and whether it will really discharge this huge burden which is being cast on it. And the first questions we are seeing being raised is around the independence of the authority, because as of now, the structure, the way it's tied, the selection process for this authority, the agency and the board members, it has too much of executive control, and there are concerns around whether then this body is going to be able to really question the government in an effective manner. Accountability remains a drawback of the current draft, because it doesn't have requirements like open consultations for framing regulations, regulatory impact assessment. It's limiting in terms of the transparency mandate that it puts on this body. There are, of course, broader state capacity concerns when you're creating an authority which is effectively acting like a mini state. It has some quasi-legislative, quasi-executive, quasi-judicial kind of functions. It doesn't have the capacity to discharge all of this in one body suddenly, or will it take time to build that kind of capacity? And finally, the interaction with sectoral regulators, because of course, in the financial sector, telecom sector, and several others, we already have standalone regulators. But there is this question about how these bodies will speak to the Data Protection Authority, and the bill makes some provisions about that, talking about memorandums of association, of agreement between the two bodies. But really, that again is something which needs to be seen. So in all of this, we're seeing a lot of developments. All in all, it's clearly a positive direction we are moving towards, but there are a lot of open questions that remain about how this will really be rolled out and when. Thank you.
Thank you very much, Smriti, for managing to providing such a comprehensive and thorough presentation in only 10 minutes. We see that to the massive size of India and its population correspond some really massive challenges. India has already shown a interest in datafication of its population with the Aadhaar system, now probably linking this to the system that will oversee the vaccination for COVID-19, while the bill, the data protection bill is still a bill and not yet approved nor enforced, and the new Data Protection Agency has not yet been created and will have an incredible power, as you were mentioning, combining quasi-judicial, executive, and normative powers all at once. Now let's move to another giant, at least in size, Russia. We have already been addressing with also with Andrei last year some of the key points of the Russian framework. Russia, let me remind you, is also formally considered a European country and member of the Council of Europe, so it has signed the Council of Europe Convention 108, although it has not signed and ratified the additional protocol that demands, amongst other things, the independence of the data protection regulator. Meanwhile, Russia has been implementing at full steam a new artificial intelligence strategy and also deploying on scale COVID-19 measures that rely on the processing of huge quantities of personal data. Andrew, please let us understand a little bit more what is happening in the Russian Federation now.
Thank you very much, Professor Belli. Please share my presentation because I have slides. Because I have a lot of illustrations. So it's called CPDP 2021 presentation. Can you open it? Sorry, but that's okay. In case of technical problem, I can say that first of all, we have some improvements in our situation in Russia. That because the Sovereign Internet Law, which comes into the full force in 2021. And this is the law which completely took all of the internet under the governmental control, which proposed the sovereign internet. And so all this ISPs and internet service providers should ensure installation technical equipment on networks which is the goal is to ensure its stability, security, and functioning. And sorry,
We have the presentation now. Yes.
you have the slide. Okay. But yes, first of all, I would like to begin that to present the first results of the global debates on the future of internet, and Russia was the part of it. And this is the voice of the people over the data protection. The debates took place in face-to-face order in the 10th of October. And I can see that for half of them population was it was completely gender and age balanced. And could you please show the next slide? And we can see that the internet considers people as a basic human right. All people completely agree with this notion. But first of all, people consider internet as the place for entertainment. It's not the place for make some serious activities. And this is the problem of I can see the problem of the Russian population with that. They don't consider their privacy or data protection as something really, really important. They consider the internet as something subsidiary, and most of the population of people will not consider their privacy as a crucial thing. But I think due to the COVID-19, the situation has changed because life of all people comes completely online, not completely actually, but in in a large scale. The life of the population of Russia, especially in big cities like in Moscow, can transfer to the online space, and the role of the internet increased. But actually, you can see that people not considering the internet as the safe space. Actually, because you consider internet as a safe space, people are disagreeing basically. Next slide, please. So there's about the confidence of the internet. So people are really don't trust, not the internet actually. They don't trust. They are not confident with the governmental policies related to the internet governance in general. Actually, the level of the personal security of people is not increasing, but actually people the problem of openness of the power is not actually not on the best scale, and people are really aware of the growth of the fake news dissemination, about the phishing, about cybercrime, about hacker attacks on the personal web pages, or things like that. I can see that, for example, I have a personal experience when I was the person who joined the defense of PhD thesis of one of my colleagues. This PhD defense was completely online, and this Zoom session was hacked by the network hooligans, and this is a very bad incident. That's on my personal actually experience. Next slide, please. This is about who should take care of the internet. People don't believe actually private sector companies. They don't believe in the platforms that they should take care on the people's privacy, on the people's data protection. And they don't believe actually local governments. They generally believe in actually research community in academia. They believe in civil society, and they believe in international organization and technical community. This is the real voice actually of the people, of the debate participants who are participating in these debates. Next slide, please. And you can see that the role of the internet, and you can see this blue, the light blue part, that the internet made lives of the people better during the COVID-19 pandemic. They're using services. They actually trying to make it working online actually, and the role of the internet completely increased, especially in the big cities actually. But the role of the internet is completely increased during this 2020. Next slide, please. Here you can see that the rights and even digital rights of the people during the COVID-19 was a bit restricted. For example, we can see some cell phones of surveillance. We can see monitoring of the people, people's behavior during the to follow the infected people. You can see a bit surveillance of the people gathering in some places. You can see even drone control. You can see some official information limitation and other things like that. And also there were some violations of the freedom of speech during the free fake news law. So all people can show that actually the criticism against the state authorities during the COVID-19 pandemic is faced the persecution under this fake news law, and also this fake news law could be used not only on official news sources, but also on blogs, on the personal pages. Use legal analogy of this fake news. Actually, the internet, even in the auspices of this sovereign internet infrastructure, it could be a really big instrument for restricting human rights. That's why I'm really criticizing the sovereign internet law. I'm really criticizing its the full implementation in 2021. But I think and technical experts confirm that it's not possible for the state to implement this in this in its full capacity. Next slide, please. So I just talk about this, but first of all, just to talk about one thing. This law postulated to creation a national domain name system. Also, technical experts considering that establishing national domain name system is not possible. So the domain name system is actually a global thing. It's not possible to spend money, spend resources to create this domain name system. Next slide, please. And this is about artificial intelligence strategy, but it's just a strategy. I don't think this its development is not really implemented. I cannot see de facto implementation of it, maybe because of the COVID-19 pandemic, but maybe after that we can see some developments of this. I think I could complete my presentation. I think I'm over time a little bit, but Russia is really sure that it will be conventional regulation of the internet, and but it try to cooperate with foreign countries on doing that. I think I'm finished. Thank you very much.
Thank you very much, Andre, for providing also this analysis of what is the perception of data protection and privacy issues in the Russian population and how this has evolved, I would say quite importantly, over the past months during the COVID-19 crisis. Very interested to see how will the artificial intelligence strategy that has been heralded as, and at least announced as something extremely meaningful by the official media, how this will evolve in the next months and after the pandemic is maybe not solved, but at least tamed, as we all hope it will be soon. Now, last but not least, of course, to conclude our presentations. And before I announce Danilo, I would also like to remind to all the participants online that if they want to share any questions, they have a window on the right of their screen where they can share any questions, and we will deal with them right after Danilo's presentation in the question and answer final part of this webinar. And Danilo, we have seen the new data protection law of Brazil, LGPD, entering in force in September. A new authority is going to be created. Actually, it's already in the process of being created. Only last week, one of the biggest, largest data leaks of Brazilian history happened. So we have a lot of news coming from Brazil. Please, Danilo, the floor is yours. And thank you very much for being again with us today.
Thank you very much, Luca. Thank you for organizing this Brics panel. I want to salute and thank all the colleagues who presented very insightful and interesting presentations before me, and Ray, Smriti, and Svais. Yes, in fact, Brazil is in the middle of a rather interesting time regarding data protection because the law entered into force last September, and its implementation is beginning to show its actual effects. I want to enter something like this, but I wouldn't want to miss the opportunity to talk a brief about the context Brazil is in, and also to stress the similarities that we might try to find and organize among other Brics experiences. I believe that this protection is finally entering a truly global framework, global rules and global concepts in order to make it possible to share that internationally with the transporter that transfers, and also to make those protection systems to relate with themselves are every day more important. Brazil have this new law, LGPD, which entered into force on, as I mentioned, September last year. Its legal aspects are important, very important. We can stress a bit of them, but the thing I would like to mention is also that Brazilian protection framework has been in preparation for at least 10 years. It's now 11 years since Brazil first started its first public consultation of a data protection legal framework, which is the same framework we have enacted in 2018. In 2015, there was second public consultation. So this is a movement which is similar to other countries, such as what's happening right now, precisely in China, for instance, as Professor Ray mentioned. But the timing of this making of LGPD is also very important, because Brazil, as indeed other Brics countries, haven't followed strictly regional trends. If you map how data protection has developed in Latin America, we can easily consider that Brazil hasn't followed other countries, other similar countries, let's say, such as Argentina, which has its data protection law enacted in the year 2000, but even Colombia, Mexico, Uruguay, they have very different dynamics. And Brazil followed a very peculiar trend, because if you take 2010, when we discussed the first draft data protection bill in Brazil, it wasn't sure. Nobody was sure if Brazil would follow an approach more similar to Europe on data protection, or if it is going to bet on a kind of US approach. It seemed to many at the time that Brazil could follow something similar to a US approach, in the sense it have built some data protection important rules based on consumer privacy and consumer law. And maybe it's possible to make some comparison with other BRICS countries, such for some time China relied a bit on consumer law, on tackle privacy issues also. So there were some characteristics of Brazil that were unlike other Latin American countries, which made Brazil took a different path, and maybe those same characteristics are more akin to other BRICS countries, to other BRICS experiences. For instance, Brazil has a market and an economy which size is considerably bigger and most consistent than other regional countries, other countries of this region. Brazil plays a role of regional leadership in so many aspects, and politically, economically. Its internal market is also big, so the leverage of Brazil on negotiating data protection rules with other countries, with major nations, were different than other Latin American countries. In this sense, there's a room to find resonant similarities with other BRICS countries. For instance, right now, when we are on the eve of starting relying on global standards and global rules on data protection, we may find out that the typical European rules maybe have problems when they try to extend globally. So maybe some shared experiences on trying to find a regional among BRIC countries on transborder data flows, considering the leverage, the internal market, and the portion of the size of the BRICS economies, shall be an important point to draft what will be a truly global data protection perspective in the following years. So I believe this panel and other experiences on the matter are so important to find out also where in each point our experience, our shared experience, may form the basis of a more unified approach to some so important issues on data protection, which may help to share this global experience. This resonance is very important, because data protection is becoming too important to all BRICS countries. And even if you reach the phases, this period of drafting or legislation a bit later than other countries, such as European ones, the geopolitical importance of the bloc is so important, and the dialogue on the countries is so important, also to stress some similarities and differences among the European countries. I would like also to stress other points, as Luca Belli has mentioned. For instance, in Brazil, okay, the data protection law is only some months old after its implementation. But data protection is not a new thing at all. We can stress that in the early 2020, about 1 year ago, our Supreme Court has recognized a fundamental right to data protection, which means that, as in other countries, even if the legislation on data protection is not completely installed or enacted, the moment for data protection is very important, it's very strategic. I used to mention that you can postpone sometimes the data protection legislation, but it's impossible to postpone data protection as people demand it, as even the government and enterprises demand data protection to have legal security on their data processing practices, to find ways to collaborate, to share information legally with other bodies, with other institutions, enterprises, and even countries. So it is a demand which is strategic, not only for the protection of citizens, but many other points in the information society and in the information economy. My last point, as also Luca mentioned, is that in the implementation of LGPD, of the Brazilian Data Protection Law, one very important point is the creation of the Brazilian DEPA, ANPD, which stands for National Data Protection Authority. ANPD was formally created last November 2020. Its directors are in charge already working, but the DPA itself hasn't started to do anything other internal work, which means they are working on their internal documentation, internal rules. They are still finding people and indicating people to make their staff to work with them. But at the same time, the dynamics of data protection and of the problems related to personal data cannot wait for the authority to finally be ready to work. In this year of 2021, we are yet in January, but we have at least two major situations that demands ANPD attention, and until now haven't received any formal comment, which is firstly a global issue, which is the change, the modifications on WhatsApp privacy policies, which called for a huge reaction in Brazil among citizens, among institutions in general. And the second, which Luca Belli mentioned, is a very huge data leak, which we don't know precisely nor officially where it came from, but it looks like it's a major data broker which leaked data about more than 2 million Brazilians, which is nearly the entire population, and 40 million enterprises. And it's not like, let's say, normal data leak, if there's something like this. It is a huge data leak because the data, which was, as it was shown by Brazilian press, covers an extensive amount of data and analyzes on data of those people. So it's very important to follow what is going to happen after this, even because consider that ANPD is not the sole solution, is not the sole resource for Brazilians dealing with data protection. We have also a major position played by consumer offices, the public ministry, and maybe other institutions. And it will be very important also to define how the ecosystem of LGPD enforcement will be. This is a major data leak, and what follows the reaction to this data leak will be very important to define what people in Brazil can expect of the implementation of LGPD. And that's thank you very much for recalling about the time, and that was my message. I give the floor back to Luca Belli. Thank you.
Thank you very much, Danilo, for this. And it is very good also to have this, to start with this more regional and even global perspective. Actually, for those who are interested in understanding a little bit more the data protection dynamics in Latin America, we are also having a session on precisely on this, on data protection issues, including also COVID-19 measures that have been taken in the region. We are having this session today at 6:30 Brussels time here at CPDP 2021. And a very important also what you mentioned, Danilo, that this movement have to some extent shown a convergence amongst Brics countries, also because they take inspiration from good or even bad practices of other nations. And on the other hand, it's also very important to stress that the people and businesses are also demanding data protection, not only to protect rights of in the individuals, but also to provide juridical certainty to businesses that are starting to see this also as a competitive advantage. Now, let me open the floor for some Q&A for this last part of our session. We had a question about precisely on this. It's good that we have finished our presentation with debating DPAs, because we have a question on the role of DPAs. So are the DPA, and this is also a very good comparative question. So are the DPAs, the data protection agencies, those who exist at least, are they independent, and what are their powers? So it's a quite general question, but I hope you will be able to provide concise replies, so then we can move to other possible questions. We may be starting with Sizwe, and then let's keep the same order we had. So Sizwe, Wei, Smriti, Andri, and Danilo. Please.
Hi there.
Yeah.
Can you hear me? Okay. Yes. I really believe that, you know, the whole revolution of data protection, it has really, you know, it has really impounded so nicely upon us as South Africans, because I want to tell you, you know, we as South Africa are always seen as the leaders of Africa in whatever we do. And for a very long time, you know, we were actually on the back burner on data protection. So it really gives me a lot of pleasure to hear that not just on South Africa, but also on the Brics side, of which we are part of, that data protection is really being prioritized now. Because like I said, it's an important human right. And because of that, you know, the right to privacy, one really needs to protect same. And I mean, I've recently seen that even the United Nations has come up with a document now dealing with digital privacy rights. So I think it's a long sought for thing, and it's something that had to happen. And I'm glad that it's happening globally now, and as well as on the Brics platform. Thanks, Bob.
Thank you very much, Sizwe, and for this observation. And just wanted to come back to the question that we were providing. So also for our audience to understand if the information regulator of South Africa is formally an independent authority or not, because this is also something very important.
Yes. I forgot to answer that part, sorry. The information regulator is definitely independent. In our legislation, it actually says that we are only accountable to the Constitution as well as Parliament. Even when members are elected through a democratic process in Parliament. And then after that, the minute goes to the state president, and then the regulator is entirely independent. In other words, even if the state president of our country, like it was last year, were to complain about the abuse of his personal information, then even he is a data subject, or even if his office would be the subject matter of abuse of personal information, we would even approach his office and call him to account. I hope that answers the question.
Yes, thank you very much, Cecil, for this. And it's very important to have this institutional understanding. We don't have yet an authority for data protection in China, but we may start understanding which entities will deal with this and how it will be implemented, right?
Okay, thank you for this question. I think, as I have mentioned, that there largely in the PIPA, the Personal Information Protection Act, still mentioned the National Administration of for Cyberspace. I think this administration will be the one of the regulators in China for data protection. But I have experienced, from my own experience, I think the Ministry of Industry and Communications, there is actually under it is a working group dealing with the privacy issues arising from mobile applications. And I think, as I know, there are some legal professors who are engaged with this working group. I think probably it will be an alternative to the national automation for cyberspace in some degree. Yes, I hope it works for your question.
Thank you very much for this, Wayne. Very good to understand that also there is some construction of probably new bodies in China to deal specifically with this, and it will probably be interesting to see also other Brics experiences to sketch good practices. Danilo and myself, we are preparing some research on this, so it will be very good then to have a further conversation on this point. Smriti, please go ahead.
Yeah, thank you for that question. So, independence can be seen along several aspects, and one part of it is the selection process that I mentioned, which in the current bill is problematic because the government has a lot of control in the manner and who will be the members of this authority. So that is one thing which impinges in some ways on independence. Another question is around the funding structure and financial independence. And there, again, a large part of the funding will come through grants from the government, certainly so in the initial years. And that, again, will question independence to some extent. And third is a provision that we see in the bill, and this is unfortunately seen in many Indian laws, almost most laws which create a statutory authority, where the government has the power to give directions to the authority. And this is something which exists on the book, is not really known to be used often, but in this case becomes particularly important and worrying because, as we were discussing, this is a body which is the regulator of the government itself. Unlike many other regulators which regulate mainly private entities, here is a body that's going to regulate state agencies, and therefore this power to give directions really has the possibility of impinging on independence.
Thank you very much, Smriti, also for highlighting that we are going to see in India a new entity that is going to have authority also over the government, and that is very relevant also. It's a very relevant character that is not common to all Brics, but some of them, of course. We are going to, I think, to wrap up and finalize in the next couple of minutes. So I would ask to Andre and Danilo to reply to this, and maybe also provide a couple of concluding remarks if they want, because we will have to finish in a couple of minutes. Andre, please.
Well, thank you, Professor Belli. This is a really big problem, actually, that inconsistent with the provisions of the Convention 108 of the Council of Europe, that the DPA, that Protection Authority, should be independent. But in the Russian Federation, the major Data Protection Authority is Roskomnadzor. You know this word actually, Roskomnadzor, which is Russian Federal Authority, which is under agency under the auspice of the Ministry of Communications. So it's governmentally dependent agency. This is the major point of criticism of the Russian legislation for the provisions of, from the point of view of provisions of the Convention 108, or the just the order of the regular data protection in the majority of countries. Of course, I think that data protection authority should be independent, and this is the error actually in the Russian legislation, that the data protection authority should be independent, and I think we should go on this way, and I think we should follow it. Thank you.
Excellent. So, Danilo, some final remarks?
Yes, just about the DPA, the National Data Protection Authority, ANPD in Brazil, is not independent, as it's part of the Presidency of the Republic, right built into the direct public administration, even if its directors have a fixed term, and in theory cannot be dismissed, made out with prior investigation or process. The fact is that the authority is entirely dependent on the budget of the presidency. It lives inside the presidency, so it's very difficult to imagine that it would follow a really autonomous path when some critical issue comes out. There is an idea of the authority to develop into an independent organization in the following years, but it's not the we have right now. And regarding the powers of the Brazilian DPA is more or less akin to a general DPA in Europe, but in fact, if it lacks authority and independence, it's very difficult to use correctly those powers. And that I believe that the shaping of the DPAs in Brics shall be another issue to follow in order to find the similarities and share experience. Thank you.
Thank you very much for this, Danilo, and we will be able, of course, also to explore this further at 6:30 Brussels time with also with Miriam Wimmer, one of the directors of the new Brazilian DPA. Thank you very much for everyone for joining this. Excellent presentations, excellent debate. We have shared also on social media further resources. If you are interested in these issues, please also visit our website cyberbrics.info, where you will find a lot of open access publications on data protection and other issues. Thank you very much for your participation, and I wish you an excellent CPDP 2021.
Thank you very much. Thank you.
Thanks.
Thank you.
Thank you.
Thank